The week after I reported the fraud, my manager called me into a meeting and told me my role no longer existed. I want to tell you about an email. A specific email sent at 11:23 on a Tuesday evening from a corporate account to a personal one that should not have existed, that the person who sent it believed had been deleted, and that arrived in the Employment Tribunal hearing room on a Thursday morning in March inside a manila folder that changed everything. I'm going to tell you what was in it, but not yet. First, I need to tell you what the 14 months between that meeting and that Thursday morning cost me, because the email only means what it means if you understand what came before it. My name is David. I am 47 years old. For 14 years, I was a senior compliance officer at a mid-sized financial services company in Birmingham. I was good at my job. I want to say that without false modesty, because false modesty has no place in this story. I had 14 consecutive years of performance reviews at the highest 2 ratings. I had built the compliance function from 4 people to 11. I had managed regulatory inspections, internal audits, and 2 significant disciplinary processes that had resulted in formal findings against other members of staff. I understood the rules. I had spent my career making sure other people followed them. In the spring of my 14th year, I found something wrong. The specifics involve client fund handling, and I am going to describe them precisely because precision is the point. A pattern of transactions had been processed over an 8-month period in which client funds were moved through a suspense account, a legitimate temporary holding mechanism, but then settled in a way that reduced the recorded liability by a cumulative total of £214,000. Not misplaced, not a processing error. Reduced, deliberately, in small increments, in a way that would only be visible if you were looking at the cumulative picture across the full 8 months. I was looking at the cumulative picture because it was my job to look at the cumulative picture. I took it to my manager. His name is Neil. Neil was 53 years old, had been with the company for 22 years, and had, I later understood, been aware of the pattern for at least 4 of the 8 months I had just documented. He listened to my presentation. He examined the transaction logs I had compiled. He said he would escalate it to the board's audit committee and that I should continue my regular duties while the matter was being assessed internally. I left his office, walked back to my desk, and filed a formal protected disclosure under the Public Interest Disclosure Act 1998 in writing to the Financial Conduct Authority that same afternoon. I want to pause here because I know what some of you are thinking. You are thinking, why not wait for Neil's internal escalation? Why file externally the same day? And the answer is the thing I want you to hold as we go forward. I had worked in compliance for 14 years. I knew what internal escalation looked like when it was genuine. And I knew, in Neil's office, watching the particular stillness that came over his face when I placed the transaction log in front of him, that what I was looking at was not surprise. He already knew. And a man who already knows and calls it an assessment is not escalating. He is buying time. I was called into Neil's office 8 days later. Human resources were present. The meeting lasted 19 minutes. I was told that following a review of the organizational structure, my role had been identified as duplicated, that the function could be absorbed into the existing senior management framework, and that my position was therefore at risk of redundancy. The process would follow the statutory consultation requirements. Redundancy. I want to tell you about Marcus, because he is the part of this story I find most difficult and the most important. Marcus was 39 years old, my deputy, someone I had recruited, trained, and mentored over 5 years. He was technically excellent and professionally ambitious, and I'd understood those qualities as straightforwardly good things. When the redundancy process began, Marcus was asked to provide a statement on the division of responsibilities within the team. Whether, in his view, my role was genuinely distinct from the functions covered by the senior management layer above me. I know what he said because I obtained the statement through the tribunal disclosure process. He said it was not distinct. He said the overlap was significant. He said in writing that in his professional assessment, the compliance function could operate effectively without a dedicated senior officer at my grade. He said that knowing I had filed the disclosure, he said it knowing what it would be used for. The redundancy was confirmed 6 weeks later. My salary at termination was £68,000. My statutory redundancy payment was £22,400. I was 46 years old with 14 years of specialist experience in a sector that, once you have been exited under a performance or restructuring process, looks at your CV with a wariness that no amount of explanation fully dissolves. I know this because I spent the subsequent 8 months applying for 43 roles, reaching final interview stage for 7 of them, and receiving 43 rejections. The financial services compliance community is not large. Word travels in ways that do not appear in any document. My mortgage had 11 years left. My son was 16. I am telling you this so you understand that the quiet fury I carry about this is not abstract. It is denominated. It has a cost I can calculate. I filed a claim at the Employment Tribunal in Birmingham. The grounds were automatic unfair dismissal under the Employment Rights Act 1996, specifically the whistleblower provisions and detriment as a result of a protected disclosure. My solicitor was a woman named Helen, who practiced in employment law in Birmingham and who brought to the case the specific quality of someone who's professionally outraged by what she's reading, but disciplined enough to convert that outrage into argument rather than noise. She told me at our first meeting that the case would turn on one thing: the timeline. Whether we could establish, beyond the employer's competing narrative of legitimate redundancy, that the protected disclosure was the operative reason for my termination. The company's defense was prepared and it was coherent. The organizational review had been in planning for 6 months prior to my disclosure. The restructuring affected not just my role, but 4 other positions across the business. The redundancy process had followed statutory consultation requirements precisely. Marcus's statement was supported by 2 additional assessments from external consultants. On paper, it was a redundancy, clean, documented, defensible. Helen sent a data subject access request to the company under the UK GDPR. It is a standard tool, a formal legal request for all personal data held about an individual, including internal communications. Companies are required to respond within 1 month. The company responded in 28 days with a disclosure that ran to 340 pages. They had clearly reviewed it carefully. They had clearly removed anything they considered sensitive. They had not removed everything. On page 207 of the disclosure, in a thread of internal emails about the organizational review, there was a gap. A sequence of 4 emails visible in the thread with a 5th response. The metadata showed it existed, missing from the disclosure. The gap was small, the kind of thing you might not notice if you were not a compliance officer who had spent 14 years looking for exactly this kind of anomaly in exactly this kind of document trail. I noticed it. I flagged it to Helen. Helen filed a further request specifically for the missing document, citing the metadata evidence of its existence. The company's solicitors responded that no such document could be located. Helen made an application to the tribunal for a specific disclosure order. The order was granted. On the morning of the hearing, a manila folder arrived. Inside it was a single printed email sent at 11:23 on a Tuesday evening from Neil's work account to his personal Gmail, written 4 days before the redundancy meeting, addressed to no one. It was a draft he had forwarded to himself, the kind of thing people do when they are thinking through a document they want to have access to outside the company's server. The email was 11 lines long. I'm going to tell you what 3 of those lines said. Line 4, the disclosure has created a significant risk that needs to be managed before the FCA investigation reaches the audit committee. Line 7, the cleanest route is a restructuring that removes David's role entirely. This needs to look process-driven, not reactive. Line 9, Marcus has confirmed he will support the assessment if asked. The tribunal panel read the email. They read it in silence. The employment judge, a woman named Sarah, looked at it for longer than she looked at anything else in the hearing. Then she looked at Neil's solicitor and asked whether his client wished to revise any element of the company's defence. The solicitor asked for an adjournment. Sarah gave him 30 minutes. The company withdrew their defence of the dismissal during the adjournment. They accepted that the termination had been in retaliation for a protected disclosure. They accepted automatic unfair dismissal. The question that remained was remedy. Sarah awarded the maximum compensatory amount available under the Employment Rights Act 1996 for automatic unfair dismissal on whistleblowing grounds, £105,707, adjusted for the Polkey reduction and contributory conduct assessment, with no deduction applied on either ground. She also awarded the basic award of £22,400. The statutory redundancy payment I'd already received reframed. She made a recommendation under Section 49B of the Act that the company review its internal disclosure handling procedures. Total awarded £128,107. I want to tell you something about Neil, because I promised I would give you his dimension, and not just his function. Neil had spent 22 years building something inside that company. A reputation, a team, a version of himself that he believed in. When I put the transaction log on his desk, what he saw was not just a compliance issue. He saw the end of that version of himself. The audit committee, the regulatory investigation, the career that had taken 22 years to build, potentially unraveling because a compliance officer had looked at 8 months of cumulative data on a Tuesday afternoon. He was not purely corrupt. He was frightened enough to write that email, frightened enough to approach Marcus, frightened enough to make every mistake in sequence, in writing, because frightened people in senior positions consistently underestimate the paper trail they are generating while they generate it. I have a new role now. It took 11 months to find. The money arrived. The mortgage continues. My son is 17. But here is the detail from the start of this story transformed. The meeting in Neil's office, the 19 minutes, the particular stillness on his face when I put the transaction log in front of him. I have thought about that stillness many times since. At the time I read it as concealment, as calculation, as the face of a man who already knew, and I was right about all of that. But I have come to understand that it was also the face of a man who had in that moment already lost. He just did not know it yet. The email existed before I left his office. The trail was already laid. £128,107. And Marcus. He's still at the company. He was not a party to the proceedings. His statement was referenced in the judgment as evidence of the coordinated nature of the retaliation, but he faces no formal consequence from the tribunal. I have thought about what to do with that. I have not decided yet. Here is what I want to leave you with. The Public Interest Disclosure Act exists to protect people who do what I did. File, report, go on the record. The protection, as I discovered, is real, but it requires you to fight for it. Through a tribunal process that takes months, costs emotional reserves you did not know you had, and depends on an email that a frightened man forgot to delete. That is the protection. An email that almost wasn't found. If you had found what I found, the £214,000, the 8 months of data, the face in the office, would you have filed? Would you have filed that same afternoon knowing what it would cost? Because I have been asked that question, and my honest answer is yes. But I understand completely and without judgment why someone might answer differently. And that answer, and what it means for the people in every office in the country right now, sitting on something they have not yet reported, is worth thinking about.